Good afternoon, everyone. I'm Amy O'Hara. I am the president of the Association of Public Data Users, or APDU, and I want to thank you for joining us this afternoon. So starting with our town halls in early 2025, and again at the unconference we held last summer, we heard a recurring theme that APDU members and the general public, they're really concerned about data privacy. And there's recent polling from the Center for Democracy and Technology, CDT, that suggests that concerns about data privacy are widespread and bipartisan. More than 80% of people across the US said that having legal protections for their sensitive information that government agencies collect and store is really important. But less than half of them know their legal rights. And this spans political parties. There's broad interest in protecting people's information from threats, including security breaches and government misuse. And it's not just the public that has knowledge gaps. As we've embarked on this work, including providing technical assistance to litigators, legislators, journalists, advocates, and privacy technologists, APDU's team noted information gaps and among different groups working on data policy. Tech folks talk to tech folks. Policymakers talk to policymakers. It's like having a room full of people who are blindfolded touching an elephant. Privacy tech understands one piece of the puzzle. Policymakers, hopefully, understand another. Advocates, a third. Data users, a fourth. Litigators, a fifth. And there's been little communication and knowledge sharing across these groups. And in addition to these information silos, we also found that some of the information out there isn't quite accurate or up to date. So with support from the Annie E. Casey Foundation, we brought together a team of experts to help fill those gaps and raise awareness so that we can work more effectively, hear each other, learn from each other in order to strengthen data privacy protections. So today, I'm pleased to introduce Maya Bernstein, who served as the Senior Advisor for Privacy Policy in the Office of the Secretary of HHS for over 20 years, until April 2025. She started her federal career at OMB, the Office of Management and Budget, where for 9 years she oversaw federal privacy policy and the Privacy Act of 1974. She was involved in the development and implementation of most major legislative initiatives of the Clinton era, including HIPAA, the privacy rule, immigration reform, welfare reform, the Brady Bill, e-commerce initiatives that fueled the internet boom. And during this time, she also earned a law degree. She briefly practiced law, returned to the government as the privacy advocate for the IRS, and after moving to HHS, worked on privacy issues that spanned the breadth of HHS activities, and that touched on HIPAA and health IT and human subjects and statistical confidentiality that we all care about, and so many more things. And in recognition of her distinguished service to the federal privacy community, the Federal Privacy Council presented her its 2021 Award for Excellence. In addition, we have Bethanne Barnes, who served as essentially the Chief Data Officer for the Administration for Children and Families at HHS starting in 2019. In her work there and in her prior role as the Special Advisor for Evidence-Based Policymaking at OMB, she played a leadership role in advancing the responsible use of data. This is consistent with privacy protections in order to improve federal programs. Among other things, Bethanne's team released the Privacy and Confidentiality Toolkit. They conducted a review of state privacy laws related to human services. They streamlined the data sharing agreement development process, and they provided privacy-related technical assistance across the human services programs administered by ACF. There are more than 60 of them. So when these two talk about the federal data privacy landscape, it's because they know the federal data privacy landscape. And we're so lucky that they are working with us and willing to share their time and expertise with all of us. And I hand it over to them.
Thanks, Amy, so much. So getting started, we wanted to talk a little bit about the Failsafes project, which we really came about because we were looking around us over the past year and saw the dramatic and rapid changes in how the federal government was approaching data, really in every way. Collection of data is different now, data sharing and use is different, data availability to the public is different, and crucially, a bunch of safeguards or fail-safes were under threat or disappearing. And many groups were already doing really good work addressing some of those issues, like the disappearing data and threats to the statistical system. But we saw that the privacy, data governance, and security safeguards and processes were no longer working consistently across government. That is, the fail-safes are failing. And that's how we got our name. And the fact of the matter is that these privacy and related fail-safes are a combination of legal and procedural knowledge and practice. And some of them are based on historical convention. This is really esoteric stuff, especially on the privacy law and internal federal government processes. There just aren't that many people who know how this stuff works in practice. And that knowledge gap makes it more difficult for people to take effective action. So we've been working to close that gap in two ways. First, as you, Amy, mentioned at the top, we've been providing technical assistance to a wide variety of folks on privacy, data governance, and related topics. Second, and why we're here today, we produced a set of educational products. And these are really just the facts educational products. They do not and are not meant to capture the current state, which is rapidly evolving. Rather, they're meant to help you understand the play-by-play at a deeper level. For example, when you're reading the news, or when you get a request for your organization's data, or you're reading the Federal Register and trying to figure out what the data flows look like. We've been thinking of these products as falling into three categories. Primers are in-depth but not exhaustive looks at an issue. Think about 10 pages. They are enough to get a good handle on the outline of an issue. They explain complexity, share context, or provide analysis, but they don't go into every nuance or detail. Briefs are rapid, high-impact orientations to a topic. Think 2 pages for an executive audience. They give you the essentials that you need to know to be able to engage. And quick start guides are the longer how-tos or how things get done explainers. They're designed to enable you to actually go through a process, like submitting a public comment on a privacy notice. They can also be useful in helping you to assess whether something was likely implemented in the way that it was supposed to be implemented, right? Like if you're looking at a document and trying to figure out if the agency followed the rules, it's helpful to know what those rules are and how they're likely to show up in the document that you're looking at. In these guides, we also include friendly insights and tips that we've developed and gleaned from our experiences, intended to maybe help make your life a little bit easier. We designed this mix of materials to be agile and hopefully not to overwhelm. They're mutually reinforcing, and we take pains to write these in plain and approachable language. As a part of that, we also call out what I call the negative space. For example, if these people are covered, that means these people are not covered. But enough about me describing what we were trying to do. I'm going to turn it over to Maya to talk through what we have actually done and are releasing today.
Great, thank you so much, Amy and Bethanne. So the first document that we released, and the most basic one, is our primer on the Privacy Act of 1974. That's one of these 10-page documents that Bethanne described. This is the foundational document about the Privacy Act. It describes the origins of law, its basis in a code of fair information practice, and it will take you through all the major provisions, although, as Bethanne said, not every detail, but enough to have you understand the scope of the law. It'll explain which entities have to comply with the Privacy Act, mostly federal executive branch agencies. It turns out that it doesn't cover the immediate office of the White House. It doesn't cover the Congress or the judiciary. So if you send records over there, any of those places, they're going to lose their protections. The document also tells you which individuals are going to get rights under the Privacy Act, what specific rights the law actually conveys, and then what obligations it imposes on those covered agencies, so you understand sort of how it works. There's, obligations of agencies and sort of the concomitant rights that match up to the obligations that agencies have. We're going to talk about that primer in more detail on April 27th, so make a note on your calendars if you want to learn, a general overview of the Privacy Act. That's a good thing to sign up for. And I think they're going to put the the notes both on the primer and on that, the sign up for that webinar in the chat so that you can follow it.
Before you go on, I got a question. When you guys were developing that brief, I heard something that you guys asked Google Gemini to review the draft for readability. Could you perhaps share with us how did that work out?
Sure. So this is part of our ongoing commitment to that plain language and readability, right? We were using Google Gemini as a naive reader, right? Like prompt, you are a smart person who doesn't happen to be an expert in this, right? Like, what are your takeaways? What's confusing? And Gemini, when I was putting this document through, it kept coming back with different paragraphs that were describing how the law works. And it was like, these things are confusing. They should be rewritten. And what it was trying to do was it was trying to fix the law so that the law was less confusing. And I was like, oh, that's so sweet. That's so sweet, Gemini. But that's not how this works. We can't actually fix the law by changing how we write about it here. Right? Like what we need to do is make sure, no matter how stupid and confusing the law is, we need to make sure that we're describing it accurately. And Gemini was like, okay. And so, put it through again, and it comes back completely unprompted with this. It's like, okay, you said I can't rewrite it. So I just want to let you know, these are the things that successfully alarmed me. And it just kept going with these insights unasked throughout the rest of that review process. Okay, sorry. Back to you, Maya.
Indeed, as I recall, it said it was alarmed, which I thought was funny about the protections that were missing from the Privacy Act. It's over 50 years old at this point. That was pretty funny. So anyway, moving on. The second document that we produced is a 2-page, one of the shorter briefs. That explains the routine use exception in the Privacy Act. Routine uses are both the most flexible and also the most misunderstood provision in the law by far. First of all, the name doesn't make any sense. It's like a Saturday Night Live skit. Routine uses, neither routine nor a use of information discuss. Right? It doesn't make any sense. It makes it sound like they're similar to the need to know exception that allows disclosures internal disclosure outside of the agency, supposedly for a compatible use with the reason you collected information. Compatibility is never defined. So that causes some trouble. I think of routine uses myself, I think of routine uses as an escape valve. It allows agencies to add new disclosures to their work, to their way of operating that were not contemplated originally by the Congress in the law, as long as they go through the proper administrative procedure, and that involves publishing in the Federal Register and collecting comments and so forth. And it's complicated what is allowed under a routine use and what isn't, and what elements there have to be and so forth. So you can learn more about all of this in our training that's coming up on May 4th. And I think you'll see, if you're interested in that topic, another link in the chat about that. Then we created another issue brief, another short one, called Managing Mixed Systems of Records under the Privacy Act. So this document describes a timely topic about what immigration statuses confer Privacy Act rights, and what happens when an agency has to manage a program that includes people in multiple statuses. And it turns out that happens a lot. Surprisingly, Homeland Security came up with this idea of a mixed system during the George W. Bush administration, in part to help the administration at that time in trade negotiations with Europe. It turns out the Europeans protect us, we Americans, under their privacy laws when we go over there, but we only formally protect citizens and permanent resident aliens when over here in the United States. And that caused some conflict among, during the trade negotiations and the discussions about cross-border data flows. So we have distilled this into a couple of pages, and the current state of play, which is a little bit mixed systems, but the state of play is mixed among the agencies. And so you can learn more about this topic in a training on April 27th, and there'll be a link in the chat about that too. Finally, we created a quick start guide on how to review a system of records notice. So this document explains the structure of a system of records notice that gets published in the Federal Register. A system of records notice is, I heard Bethanne this morning in another meeting describe it as a press release for agencies. It lets the public know what an agency is doing with Privacy Act data, what they collect, how they're going to use it, and how it's going to be disclosed, and also, you know, how it's safeguarded and other things like that. And so we explain why you might want to pay attention to these, especially in the current federal data governance climate. We help you to approach a review if you've never done one before in particular. If you have only a short amount of time, we tell you like how to do this in a half an hour, the things you to focus on and the things you can skip. Or if you have more time, sort of in what order to look at them so it makes most sense, and you give yourself an approach that will give you the best way to review this kind of a document. We suggest what questions to ask yourself, you know, point out some red flags to know, the type of things you might want to comment on, as I said, what you can skip. And then at the end, this document includes a 2-page kind of checklist, a tear out for the end. It's like a cheat sheet with a summary of the questions that will guide you through the thing. And, you know, you can just sort of easily follow as you're going through one of these reviews. We have not announced training on this one yet, but stay tuned. I think we may do that. And those are the documents we've produced so far. And now I'd like to turn things back over to Amy.
Well, before we get there,
Yeah.
you mentioned a couple terms that I want to make sure that we level set with the audience.
Oh, sure.
Disclosure.
Okay. So
Tell me about the word disclosure. Is that the same as an extract, or legal or illegal, or tell me more?
Very interesting question. Thank you. So for me, a disclosure, when I have my Privacy Act hat on, a disclosure for me is any, I don't want to use the word access, but it is that too. I think of it as moving data from one party to another, but in fact, the data doesn't have to move. Any way that someone can access the data, whether verbally, orally, on paper, whether it's revealed to them in a meeting or in an elevator, any of those are disclosure if the data is protected by the Privacy Act. But it could also mean I am taking a piece of a database and I am packaging it up and I am sending it over there to another agency, and and then it is over there at that other agency, which then is responsible for protecting it. One interesting thing, I think, and maybe this is the point that Bethanne was gonna point out, is that under the Privacy Act, the protections of the Privacy Act do not follow the data around. They depend on the custodian of the data. If you own the data and you qualify as covered by the Privacy Act, your data qualifies as covered by the Privacy Act, then you are responsible for protecting it. But when I move it to another agency, if I disclose it somewhere else or to another person, it depends on whether that custodian is covered and what rules cover them. So if I send it to another federal agency that's covered, it might be covered by the Privacy Act. If I send it to a state, not covered. States are not covered, right?
Yeah.
Bethanne.
So adding on that, right, like, and just putting a really fine point on it, basically a disclosure happens anytime somebody gets information from the record, right? It's like at that point. So it could be a phone call, it could be anything, not just across agencies.
Right.
And crucially, it could be an authorized disclosure or an unauthorized disclosure. The fact of the data being accessed isn't what makes it legal or illegal or anything like that. It's the terms under which and whether or not they are supposed to be able to access this.
Good point.
Thanks. The other thing that I heard that I wanted to make sure we get clarity on how it's defined is multiple status. Maya, you mentioned this in your description of the products.
Right. I was you talking about mixed systems. Yeah. Under mixed systems. So under the Privacy Act, in the law, the only persons individuals who get Privacy Act rights are citizens of the United States and permanent resident aliens, what we informally call green card holders. That's just the way the law was written. However, you have a lot of programs where, for whatever reason, there are people in various immigration statuses commingled together. And that's because either it doesn't matter to the program. So for example, a customs and border protection, right? You're coming across the border, you still have to go through customs, whether you're a citizen of some other country or whether you're a citizen of US, so they may have a record about that. And these are all mixed up. Who has Privacy Act rights and who doesn't at the moment doesn't really matter to them. They're still going to check whatever you're bringing across the border, kind of thing. There are, for example, at the Social Security Administration, which has been in the news a lot, the Social Security database, they keep records on who is work authorized. And work authorization sort of attaches to immigration statuses, but not only to citizens and permanent resident aliens. For example, you could be a scholar coming to do research at an academic institution and have a special visa status that allows you to work and make money in the United States. You're not a permanent resident alien and you're not a citizen of the United States. Technically, you do not get Privacy Act rights. But the Social Security Administration has you in their database together with everyone else who's work authorized. And so it can be the brief talks about is how it can be difficult for an agency to have to tease out at any moment who's getting rights and who's not getting rights. And it doesn't, for most cases, doesn't matter. What Social Security cares about is, are you work authorized? You have a status that gives you work authorization, that's great. If you don't, Social Security may have an application about you, but then it didn't go through because you were not qualified to have a Social Security number, for example, because you're not work authorized. But they may have information about people in multiple different visa statuses. All, it's not divided as to how the Privacy Act divides things. It's just how it makes sense for the program to keep its records. And that could be commingled records of multiple immigration statuses. Is that clear?
That's better. Thank you. I've been keeping an eye on the chat and lots of people are saying, can we have these slides and can we have the links that are being dropped in the chat? And we're probably also going to do a summary of the questions and responses that get in there. And so just to clarify to everybody, yes, all of that is going to end up being public facing and likely linkable whenever you follow on to this recording or go to the AppDo website. There were also a couple of questions that are in the chat. I don't know if you guys want to put up your questions again, so we did get an answer to one of these for the moment that it was up there. These are questions that the team has, and we would love it if you could put your ideas in the chat today, or if you were reflecting on this and then you think of one, please email us at info@appdo.org. That would be spectacular. So while folks are thinking about these things, I just want to thank you guys for all of this work. I acknowledge that it is a huge amount of work and we appreciate your expertise applied to it. And this was just such a great overview of these new products. If there is one key point you want readers to take away when they read these, what would it be?
I think for me, when I think about privacy, I've been doing privacy work for a long time. I think Bethanne's expertise is much more broad than mine. As a chief data officer, she deals with privacy and other things as well. And mostly I'm focused on privacy. But people try to ask me to describe what privacy means. And for me, the best synonym I can come up with is fairness. So I think that when people think about privacy, they equate it with confidentiality. And that is not a good analogy for me, because that implies that you're thinking about just access and disclosure, who gets data. But privacy is about the whole panoply of rights that include things like, do you get notice up front? Do you have an opportunity to comment on things? Is your data kept in a way that's high quality? Is it accurate, relevant, timely, and complete? And those things don't have to do with access or disclosure, really. They have to do with Are we treating people fairly? Are we using data that's of high quality when we make decisions about them? Because these data are used to make decisions about people that matter in their lives, whether they get a loan, whether they have access to benefits, whether they get a job, are they going to be investigated by law enforcement? So I think about the whole group of rights that go into privacy, and I want people not just to think about access and disclosure, but to think about the whole life cycle of the data. Is it fair when we collect it? Is it fair when we keep it? Is it fair when we disclose it? And eventually when we dispose of it or archive it and so forth.
Thanks. Bethanne, got an answer to that?
Is she frozen?
Maybe. That's okay. We'll ask her again. Maya, I'm going to ask you one of the questions that popped up in the chat. What about PII data the government buys from corporations? Can that be shared across agencies?
Right. This is a very interesting question that comes up. Oh, there she is. Okay. I'll answer quickly and then we'll come back.
Okay.
So she was asking about PII that was brought into the government either by purchase or some other way. So the Privacy Act itself does not use the term personally identifiable information. The Privacy Act cares about whether there's records about someone associated with an identifier and then retrieved by that identifier. It was a way for the Congress to limit what data was actually covered back in 1974. Doesn't maybe make a whole lot of sense right now when we have full text retrieval of stuff. We have seen an increase in agencies either buying or bringing in data from commercial enterprises. If they bring it into a system of records, which they should, from my point of view, if they're using those data to make a decision about somebody, they are required, for example, under the Federal Records Act, to incorporate it into their records because they're making decisions about people, and you have to document what decisions you're making and on what basis you made those decisions. Even if it's to generate leads for law enforcement, they're supposed to be documenting that work. And if it's in a system of records, then yes, they have to incorporate it. They have to list it as a source of information. They have to list those data points as possible categories of records and categories of individuals that are covered. Does it help?
It does immensely. Bethanne, I'm going to bug you later to circle back to what do you want the main takeaway be. But in the Q&A, there was a question, how do the privacy protections for statistical data like census data, tax data, and program data differ? And I know you love this question because you will also fold in evaluation data and other types of data most of us don't usually think about. So have at it.
Oh my goodness. Okay, so can I just say, like, this is one of those things that I would love to do a brief on at some point, because especially with like the do-gooder smart people use data to improve programs community, we think of statistical data and statistical purposes as having like gold standard, solid, locked down privacy protections. And that's true for some data. If it is protected by CIPC, the confidential information protection and whatever, something, right? But a lot of data that's covered by the federal government does not have those CIPC protections. Even though we talk about it being used for statistical purposes like performance reporting or evaluations or various other things, and even though we may be including routine uses that allow people to use data in those ways, it does not carry those CIPC protections. In fact, those data are usually only covered by the Privacy Act in terms of protections, which, as Maya already explained, go away the minute that you move them outside of a federal agency, right? In some cases, like for evaluations or other research that have gotten a certificate of confidentiality, that is actually an even stronger level of privacy protections. In those cases, not even a court order can break that certificate of confidentiality. You can't be required to disclose it. But that only applies if you have gone through the process to get that certificate of confidentiality for the very specific study that you're working on. And of course, if you're working in something like health or education or some of the criminal justice data or any of those other areas that have domain-specific statutes, then those protections also apply. But this is a complicated patchwork of things. And we are frequently giving that statistical use the halo of SIPC when it does not exist. And this is especially important in the current era of AI, where statistical purposes are frequently used as code for we are going to train models on this data. That's my spiel. I could go on for hours, but keeping it short.
I agree with you that you should do a brief on it. But I think this leads into another question in the chat, which is, I would love to see, to hear about how violations to these things could be enforceable.
Yeah. Yeah. Let me start, and then Beth, if that's okay, and I'm sure Bethanne will want to add to it. The Privacy Act, is a 50-year-old law, and the enforcement provisions are not very strong. There are both civil and criminal penalties in the Privacy Act. And, the criminal penalties are punishable by a misdemeanor and a $5,000 fine. I am not aware in my 30-some years of doing Privacy Act work of any time the Justice Department has brought a criminal case under the Privacy Act, because the penalties are small. However, there have been privacy violations that they usually find some other charge to make that gives them more oomph. So there was a case in the 90s where Social Security Administration officials were literally selling off data to, a credit card information and other stuff, to criminals who were using it to do identity theft and steal credit card information and so forth. And they were charged with something like theft of government property, which has a higher penalty. So it was more worth it for the Justice Department to do that. So it's not that people aren't found to be violating, but the Privacy Act itself isn't the mechanism that they usually use for criminal penalties. On the civil side, there are civil penalties, but they're very hard to prove. So if you fail to publish a system of records notice or violate other provisions or whatever, you have to be willful and intentional. There has to be a nexus between the action that you took and the harm, and that you have to actually show harm, out-of-pocket harm, money, damages, which is very hard, right? You can't get for that bad feeling you get when your privacy is violated. You have to be able to prove it cost you something. Now, if you can prove that, it's $1,000 minimum penalty, but it's very hard to prove, and you have to prove all these different parts. So in my view, in the cases where someone can bring such a case, probably the agency did something bad and they should be getting sued. There have been Privacy Act cases like that, but they are very difficult to bring. And I think there's some movement on the Hill to amend the Privacy Act, maybe to change the penalties, people to have different proposals about that. It's a weakness.
So adding on, Maya has been sharing lots with me about how all of this works and some of the strengths and weaknesses. So I want to call out just a few additional things. One, on the civil side, there is actually injunctive authority in very limited cases. And that means that you can sue and make the agency do something, right? Like, it's not damages, it's not getting money. And those very limited cases are things like knowing whether or not the particular federal program has your data, right? Has your information. Being able to look at what they have on you and being able to request an amendment. We go through some of the other pieces in the primer, but it's primer level, it's not deep expertise. The second thing I would like to point out is that Maya frequently talks about how we all know that these are weaknesses in the accountability provisions of the Privacy Act. And also that is one of the reasons why so many of the lawsuits that are seeking to hold the government to account for their actions are pairing the Privacy Act with the Administrative Procedure Act, which has more teeth to be able to hold the government accountable to doing what they are supposed to be doing under the Privacy Act.
Right. It's a very good point. Injunctive relief, or is very limited in the Privacy Act. A judge could make them amend the record that you wanted amended. They could make them disclose a record but they can't really make them give training or stop disclosing, doing other sorts of things that you would think, when they're violating the rules. And that's also a limitation and a weakness, I think.
Thanks. That's related to another question in the chat. Is there a way to articulate a reasonable expectation of transparency when it comes to privacy or control of your things like your data?
You want to do that first, Maya, or do you want me to?
Yeah, if you have an idea about what that person is asking, I'm not quite sure, but.
Sure. Yeah. Well, so you put it back in the chat if I get this wrong. But the way I'm thinking about that question is there a way to ensure transparency over what is the government collecting on you? What are they doing with that data? Where is it going? Right? Like all of those things. And there actually is. So, and it's built into the Privacy Act. The Privacy Act requires two kinds of notices when the government collects data on you. One is a direct notice at the time of collection. So when you're actually giving the government, you're filling out the form and what the data is, one of those additional detailed forms that most people never read is the disclosure of how the government is, why they're collecting the data and what they're going to do with it.
So as an example, April 15th, I point out that your tax forms are a good example. When you look at your basic 1040, it will have a Privacy Act notice on it. That's the direct notice that Bethanne is talking about.
Exactly. The second kind of notice is called a systems of records notice, or system of records notice. And that's the SORN that we've been talking about, that we developed a whole guide on. Those are published in the Federal Register, which Gemini helpfully pointed out is where privacy goes to die. And
that is what it said.
One of the crucial things about that notice is that notice has the power to change how the government is using the data it has already collected on you without going back and notifying you directly. So those are the provisions that are currently in the Privacy Act and which agencies tend to follow. Right? Like what those procedures are. And we know there are a bunch of weaknesses in that, right? Like who monitors the Federal Register every day to see if their data is being used differently than it was yesterday? Like that's not a standard thing in most people's day-to-day activities. But that's where it is right now.
Cool, thanks. A different question in the chat. My sense is that the Privacy Act references matching of records. Does that extend to use of those systems for AI agent training to build models which would violate privacy?
The matching provisions in particular. So there is a set of provisions in the Privacy Act. It was an amendments to the Privacy Act in 1988 and 1990. And the matching provisions were originally created to think about in the context at the time, imagine two big mag tapes on mainframes where you're matching big databases against each other. The idea is to figure out on two lists, who's on both lists that's not supposed to, or who's on one list and isn't on the other list where they're supposed to be. And, but it was limited, these provisions, let me back up. So if it's a covered matching program, it requires a data use agreement and data quality and cost-benefit analysis, benefit-cost analysis, my OMB mind is telling me, and publication in the Federal Register, a notice to the Congress and OMB and so forth. But it was limited to what we would call maybe good matches. Matches where you're deciding whether somebody's eligible in the first place or for continuing eligibility for benefits or loans, some kind of in-kind, or monetary benefit. There's also a provision that covers if you're matching against your own personnel in your own agency. And most of us would think of those as kind of the good matches. People who aren't eligible for those programs aren't supposed to get the money from those programs. And it, produces a list of people who are not eligible and shouldn't be on, and can also produce a list of people who should be eligible and who we can reach out to because they need to get onto these programs, that sort of thing. But it doesn't cover other kinds of matching that, for example, immigration status or things that are not specifically benefits or loans or monetary or in-kind assistance. And so there are lots of other ways that agencies can match data together that's not covered and wouldn't have all those due process protections that I mentioned.
I would like to make an additional public service announcement, which is even in those limited cases, well, two really. So as Maya described, those computer matching agreement provisions or CMA provisions are limited to very specific sets of things, which doesn't necessarily cover AI, right? In a whole bunch of ways. So that's to answer the original question.
Right.
Like those are different things. One's a method, one's a reason. They could overlap, don't generally necessarily. Second is under OMB's August implementation guidance associated with one of the executive orders around protecting America's checkbook from fraud, waste, and abuse. OMB directed Treasury to seek an exemption from those computer matching agreement requirements for any federal agency program that is matching their data against the do not pay database for a period of 4 years. So these extra provisions, right, like these protections, like you go through a data integrity board and you get this whole thing coming out, that's going to be missing for a whole suite of data matches associated with the fraud, waste, and abuse executive orders, of which there's a series.
I think that's related to another question in the Q&A. What are the main loopholes that agencies use to avoid accountability? And as you just articulated, some of the loopholes are by design.
I think probably what Maya and I are both hitching on is the ascribing of motive to agencies in trying to avoid accountability in the loop. So I think we're both probably going to want to describe where there are gaps or shortcomings or things that Congress just didn't think of 50 years ago, or some loopholes, and how they may be used now. Does that seem right to you, Maya?
Yeah, that sounds right.
Great.
I mean, yeah, I always hesitate, and Bethanne and I have actually had this discussion about like whether we should call something a loophole or just a limitation, or, that sort of ascribes, as she said, some motivation or nefarious intent, which sometimes it's just a gap in the law or something that wasn't anticipated 50 years ago. And the Privacy Act really hasn't been amended significantly. So lots of things have changed in the environment that allow the gaps to widen, let's say.
Mm-hmm. Yeah.
Or for people to decide to figure out more creative ways to bend, law.
Yeah. So just kind of top of mind, some of the things that I think we have been seeing as patterns in authorities for how data is moving between agencies that are different interpretations than we are historically familiar with are things that fall into two categories. One is the use of the law enforcement related exceptions and exemptions, and the potential reinterpretation or stretching of what counts in that case, like what counts as law enforcement, what counts as being an open investigation, what counts as a purpose versus just general kind of phishing, right? Like those kinds of things. So that's a big category. Another big category are things related to audit authorities, which usually in the Privacy Act context are coming up under these routine uses, right? Like you publish a routine use to be able to do something related to improper payment detection, accountability, do not pay usage. And because routine uses can, like, it's like free verse, right? Like you can technically put in the SORN whatever you want, right? Whether or not that routine use is valid or would hold up in court depends on a whole bunch of other things. And but the agency can start operating under that routine use 30 days after they publish it in the Federal Register, regardless of whether or not it is tightly written and would eventually hold up in court.
Exactly. Yeah.
The third one I would mention is this whole like notice, like we're just going to update the Federal Register and apply that to data that was already collected, which maybe you would not have given to the federal government if you had known that that was how it was going to be used. But there are more.
Yeah, I think one other thing I would add is there was written into the law originally an exception that allows an agency to disclose within the agency, and the agency is defined as the whole department. So imagine where we came from, HHS. You know, HHS is this very diverse department. It's running an insurance program in Baltimore. It's running a research hospital in Bethesda. It's doing public health in Atlanta. They're regulating drugs. We're doing all the human services stuff. And anywhere among those agencies, if one of the HHS agencies collect information, it could send it to anyone who has a need to know within the whole department. And so that applies also to a place as diverse as Homeland Security, and all of the law enforcement entities that are part of that department. And it was intended by the Congress to allow agencies, it wasn't intended to put administrative blockades in the way of agencies doing business, but now it's really being stretched, I think, to a point where they might not have intended it, or it's a much broader sorts of disclosures that one might have reasonably anticipated could be made.
Great. I'm going to pull together threads on two of the outstanding questions. One is there a way to determine what agencies, acknowledging that they have data about us, is there a way to determine what they're allowed to use it for? Like permissible uses, are those identified, known, evolving over time?
Two things. Read the SORN and read the primer, because those allowable uses are defined really in two places. One is kind of the standard list of exceptions, right? And that's information you're going to find in the primer. And the second is through the agency's description of why it is collecting the data, the purpose, and in the routine uses. It's going to miss that whole category of things that are not why the agency collected it, but is using within the agency, but it's not disclosing outside of the agency. But that's as close as you can get, I think. Yeah, you have to go program by program.
Yeah, I would say if you're not familiar with the Privacy Act, it turns out an agency is not required to tell you what the statutory exceptions for disclosing without your consent are. You just have to know them. They're in the law. You can find out if you know to look there, but they're not required to tell you. They are required to tell you about routine uses because they've added those in addition, and they are required to tell you sort of their purpose for collecting and so forth. But they're not required to tell you internally to the department where they're going to send things if they later decide to send things. So you can find out some of it, but maybe not all of it.
And I think that like what you were just describing right there seemed to be like microdata or this eligible population. But there's a question, do SORNs include provisions regarding tabulations, which might entail privacy violation risk versus others that might be acceptable? So where is that line between what the agencies are using for administrative, operational, evaluation uses, and then what can be disclosed publicly that is no longer a violation? I added a lot onto what was in the chat because I too am curious.
So I'll start, and I know Bethanne's going to have more to say about this because this is more in her expertise. But in terms of compiling either administrative data, for example, for statistical or evaluation use, it's supposed to be no longer identifiable to the individual once we use it for a policy purpose like that. And there are, or were, experts in the federal government who were experts in disclosure, confidentiality, and so forth. And we relied on them to make sure that those data sets, and through the Foundations for Evidence-Based Policymaking Act, there's a whole rubric for how chief data officers are supposed to review things before they go out the door, even with the push to make more data available to the public, but also, of course, to review it before that happens to make sure that it's not disclosing identifiable data. There are experts that did that work. I'm not an expert in doing the work. But Bethanne works with them more closely. And as a former chief data officer, I'm sure she can speak more to that.
Well, I was actually going to say you stole all of my talking points, but key things to keep in mind with that are, one, there is an existing exception in the Privacy Act for these statistical, usually tabular data disclosures, which are no longer associated with individual identifiers. They're not supposed to be identifiable and all of that. And the second point I want to underline is all of those protections around ensuring that it's not re-identifiable and all of those kinds of things basically live outside of the Privacy Act.
Correct.
Maybe that's a different primer that needs done. I've got a couple of them we're getting close to the top of the hour, so I'm going to ask for short answers unless they aren't short answers. Can you explain the intersection of the Privacy Act and FOIA? Are there times when these overlap or contradict each other? You're like, no, that's a terrible long answer, Amy. Stop.
It is a complicated answer, but
okay.
Let me take a shot. So the Privacy Act, so there are sort of opposites. The FOIA has a presumption of disclosure, and there are exceptions. The Privacy Act has an assumption of withholding, and there are exceptions. The Privacy Act does not prevent disclosing something that is otherwise required to be disclosed under the FOIA. If it's required under the FOIA, the privacy permits it to be disclosed, which means there's a public interest that outweighs the privacy interest. However, if that doesn't exist, then the Privacy Act prohibits the disclosure of that information. Unless the public interest outweighs the privacy interest, you are required to withhold it. That would mean the privacy interest outweighs the public interest. There's a balancing test in the FOIA. However you come out tells you you must disclose or you must withhold. There's no, if the document is protected by, there's no in between anymore. The discretion is removed, I will say. The Privacy Act removes the discretion of the agency to disclose something they might otherwise be able to disclose.
Thanks. All right. Is there a way for someone to request what data agencies have on us from all agencies at a point in time?
No. And this is, okay, so this is one of those things that's like a current shortcoming and one that theoretically would be possible to address given current technologies and structures and all of those kinds of things, right? However, it is not the case. So right now, in order to figure out what federal agencies have on you, you have to first think real long and hard about how your data interacts with the federal system. Yeah. And that's complicated because your data could be getting into the federal system in so many ways. I mean, directly through the IRS, that's an easy one. Social Security, that's an easy one. But what about all of those programs that are administered by a state agency or a local grantee down the street or Meals on Wheels or any of those folks? Or maybe through a private data broker that has sucked up your location information from your widget on your phone and that got sold to the federal government for some reason or another. So you have to think, where might my data be? Do I even know those program names? And then I have to go search through the Federal Register to find the SORNs for those programs, and then follow the instructions in those SORNs, which usually refer to a different regulation on a website somewhere that's laid out in some level of incomprehensible language to figure out how to make that request. So that's the process.
In part, this is by design in a way. So it's very difficult to do that. In part, it's by design, because the Privacy Act is designed to be agency by agency. As I was saying, it matters who the custodian is, and the rules that apply to HHS are different than the rules that apply to DOJ and law enforcement entities. And so in many cases, you want to keep those data separately, and you want them to be controlled not all by the same rules. If we were all controlled by law enforcement rules, we'd never get access to our data.
And which is to my point about, like, in the current state of play, it no longer requires all of those data to be held together in order to make that request. You can have somebody do that, but that was not necessarily the case 50 odd years ago.
Right, but you can go to HHS, a very diverse agency, and say, send me all records about myself at HHS, and they will have to do a lot of scrambling, and it will probably take a long time, but it could be done in theory.
Probably the final question I'm going to ask out of the chat: what has been the hesitancy or justification for the lack of amendments to the Privacy Act?
I have some feelings.
That's all you, Maya.
So, I mean, for a long time, privacy officials like myself have been hesitant to either support or suggest to administrations that we've worked with to amend the Privacy Act, because we're worried that the Privacy Act could not be passed today, that the kinds of things that it limits would be not acceptable in the current environment. Or, to be a little bit frank, because I don't know all of the audience we have, when you have 535 members of Congress weighing in on something, they're likely to mess it up in one way or another. It's very hard to get a law correct in its details, and many laws we've seen have problems, either intended or not intended. And so it's very difficult and complicated to think about the current environment we're in and to make a good amendment or a good new law. But also, some things might not be able to get passed, and that's worrisome for those of us who are concerned about protecting privacy.
Okay, I didn't know if Bethanne wanted to pile in.
Oh no, that's all Maya.
Excellent, love it. Okay, I want to remind people that this is just the kickoff for a series of trainings, and you guys know what is coming up next. We've got a deep dive on Privacy Act on April 27th. We've got a deep dive on routine use exemption on May 4th. We're putting the registration links in the chat there. And I want to just quickly turn to you guys. Is there anything that hasn't been asked or discussed that you want to mention to our audience today?
I think that I just want to reiterate Maya's point about privacy, and the Privacy Act is about more than just disclosures like access and disclosures. It's about fairness. I also want to highlight a theme that has been coming through here, which is that privacy law in the United States is a very complicated patchwork that is not well understood even by folks who kind of live and breathe in this ecosystem. Mm-hmm. And there are many misconceptions about what is protecting what. Yeah. We started with the Privacy Act because it's foundational and a backbone. It is not the only thing, and there are also gaps, and just as there are gaps in the Privacy Act, there are gaps elsewhere in the law.
Okay, well, we are going to be looking to you guys to help share your knowledge about those gaps and help all of us as a community begin to fill them. And I want to remind everybody to go to these resources and read them. We've got links in the chat for all of these resources. We will be posting a recording of this to Aptu's YouTube channel. And if you want to see more events like this, please let us know by sending an email to info@aptu.org. And if you're not already getting our newsletter, you should sign up for that. These are all going to be links in the chat. And I want to thank you guys for explaining all of this and being part of the Aptu world and sharing information. And we look forward to more. And thanks to the audience for joining us today.